Welcome. My name is Michael Frumkin, and I'm the organizer of this University of Miami Law School seminar on the constitutional crisis. Our topic today is domestic use of the military. Our guest speaker is Chris Mirasola, who's an assistant professor of law at the University of Houston Law Center, where in addition to having very quickly established himself as one of the leading authorities on today's topic, he also teaches courses in international law and property law. Professor Mirisola has degrees from Johns Hopkins University, the Harvard Kennedy School of Government, and the Harvard Law School. He was also a Climenko Fellow at the Harvard Law School. Before teaching law at Houston, Professor Mirisola was an attorney advisor in the Office of the General Counsel, International Affairs of the Department of Defense. Previously, he worked for the U.S. Pacific Command in Honolulu, for the Department of Defense as an Honors Intern, and the Naval War College as a Legal Intern. Perhaps the most amazing thing to me about this extensive resume is that Professor Mirisola was able to secure the necessary security clearances for all these defense-related jobs after about 2 years in the People's Republic of China, serving first as an English teacher and then as a legal and technical associate in International Bridges to Justice, an NGO that trains Chinese defense attorneys. He has or will be published in a number of law journals, including the William and Mary Law Review, University of Southern California Law Review, University of Pennsylvania Law Review Online, and the Harvard National Security Journal, and also the Harvard Negotiation Law Review. He's also a contributor to the interesting and influential Lawfare blog. We are very fortunate to have Professor Mirisola here today to speak to us on an issue that could not be more timely or more concerning. So I'm going to turn it over to you and mute my mic. Thank you very much for doing this.
Oh, thank you very much, Michael. That's a very generous introduction. I'm very happy to participate in the lecture series. Like any good neurotic lawyer, I watched a few of the previous videos in the series and saw that Professor Somin mentioned he was glad to be the least impressive law professor to join the series, and I'm very happy to be taking that title from him today. My goal over what should be just under an hour is to help us understand kind of how we've come to live in our current environment, right, where the president has deployed hundreds of military personnel without notice and basically at his whim to an increasing number of disfavored cities. And what I'm going to be arguing is that although we can attribute some of this to unprecedented moves made by the administration, substantially more can be traced to overbroad statutes enacted by Congress and theories of inherent presidential authority, which are untethered from any serious effort to understand the text of the Constitution. For much of our modern history, we've been incredibly lucky to have elected a series of presidents who were, to greater or lesser degrees, concerned about the prospect of deploying the military in the United States. And I think that history has given us a false sense of security about the protections afforded by this body of law. So what I'm going to be talking about over the course of the rest of the talk is first just recounting the state of play that we currently have, a little bit of background on the statutory law and constitutional theories that are relevant to these deployments. Then I'm going to place these statutes and theories into a broader context of the law of domestic military deployments, and then talk a little bit about what we might expect to see in the months and years to come. Okay, so first a bit about the state of play. So since the summer, the president has deployed or attempted to deploy the military to a number of cities. I'm going to be principally focused on Los Angeles, Portland, and Chicago because they are united by a certain set of law and fact. Military deployments to DC are very important. They're also governed by a body of law that is in some ways pretty unique. I'm also going to be tabling for the moment the deployments to Memphis, which have a number of state law kind of connections that are I'm not going to get into here. Okay, so thinking specifically about these deployments to Los Angeles, Portland, and Chicago, they've been conducted primarily, though not exclusively, with members of the National Guard. And the National Guard really is just the modern day militia, right? And what that means, and this is important for understanding of the law here, is that we're dealing with individuals who on any given day are civilians. And those civilians are then brought into some kind of military duty, usually that is state duty, to act as a military force for that state or territorial governor. But these individuals can also be brought into federal service. They can be made into members of the federal army or the federal Air Force. And that's done through a number of statutory authorities I'll be getting to in a little bit. Okay, so these are the individuals that we're dealing with. What are they doing, right? And primarily, they've been performing functions that are kind of now referred to as the protective power. These are generally actions to protect federal functions, persons, and property. What does that mean? It's varied pretty considerably, and I think we've seen the broadest range of actions in the context of the Los Angeles deployment. So it's meant on kind of like the low level, standing around and protecting federal properties and buildings from protesters. As we kind of incrementally move along, kind of a continuum of severity here. It's also included things like detaining individuals who have come onto that property. In at least one case, detention for a pretty significant period of time. It's meant deploying military personnel to accompany federal law enforcement officers on deportation raids, cordoning off streets, preventing protesters from interfering with those raids, things of that nature. And in at least some contexts, it's just been like presence patrols, doing things like walking through a park to reinforce the might of the federal government. And, all of these actions, right, they're occurring in a broader context of military deployments, primarily to include deployments at the southern border. So at the beginning of this administration, as folks may remember, there was a surge in deployments of federal military personnel to the southern border in response to any number of presidential memoranda that were signed on the first day of President Trump's term in office. The military has been used to deport individuals to a variety of countries. There's been the literal militarization of the southern border, the transfer of land along the border with Mexico from the Department of the Interior to the Defense Department, turning what was once civilian property into one very long military installation, and then manning that military installation with military personnel. And then, of course, also, sending a intermittent number of individuals to Guantanamo Bay as part of their deportation. Okay, so that's, a 30,000 foot, kind of overview of what the military deployments have looked like so far. What I want to talk about now is a bit of the legal background that's underpinned all of these deployments. And now when we think about National Guard deployments in particular, I like to bucket our analysis into kind of three groups, right? So I'll walk through those for you all. So first is to identify what statutory authority is being used to put soldiers and airmen onto a military duty, right? So as I mentioned before, on any given day, these folks are civilians. You need some statute to make them into military personnel. And then second, right, once we deal with these mobilization authorities, we then ask, regardless of whether they're operating as state or federal personnel, what is the statutory or constitutional authority that authorizes the mission, right? The particular actions that these personnel are going to undertake, to perform. And then third, we ask what funding authority there is for the mission. Folks in the class have already had an amazing overview of appropriations law from Professor Zachary Price. I tend to think that appropriations law is a really underappreciated aspect of the law of domestic military deployments in particular. Okay, so running through the first two buckets is what I'm going to focus on for us all today. In LA, Chicago, and Portland, the President and Secretary of Defense have relied on Section 12406 of Title 10 to federalize members of the National Guard for these missions. Now, Section 12406 is a very old statute. In something close to its modern form, it was first enacted as part of a comprehensive reorganization of the militia in 1903. And in relevant part, it provides, quote, that whenever the United States is either one, invaded or in danger of invasion by a foreign nation, two, there is a rebellion or danger of rebellion against the authority of the United States, or three, when the president is unable with the regular forces to execute the laws of the United States, that the president is authorized to call into federal service members of the National Guard in response. So most of the litigation we've seen so far has focused on the interpretation of this statute. And there have been a couple of primary questions that the courts have been focusing on. So first is, what is the amount of deference that presidents are owed in determining whether these factual predicates are met? Right? Then relatedly, are there any objective standards that we can apply to terms like invasion or rebellion? And then lastly, and this has come up in particular in the Chicago litigation, who are these regular forces that Section 12406 is referring to? Now, to kind of start at the beginning of these questions, in litigation in the Seventh and the Ninth Circuits, all courts have agreed that the president deserves a considerable amount of deference in determining whether those factual predicates were met. And they've rested this understanding on cases like Martin v. Mott, which didn't deal with Section 12406 in particular, but dealt with a statute that has similar language. What they've disagreed on is how much of that considerable deference the president should actually have. So the Ninth Circuit has been the most accommodating, at least thus far, and the Seventh Circuit has been a bit more skeptical, which explains why it's the Chicago litigation, which is currently before the Supreme Court, and not litigation out of Los Angeles or Portland, where the states have consistently been losing at the circuit court level. Okay, and now all this is related to questions like, what does it mean to determine whether there is a rebellion, right? For example, in any of these locations, how much violence do you need for there to be a rebellion? How much interference do you need to see in the functioning of the federal government? So, for example, in Portland, there was, in the days leading up to this federalization of the National Guard, exceedingly little in the way of meaningful violence. But the Ninth Circuit panel that heard this case decided the president still properly relied on Section 12406 because it elongated, for example, the period of time that it could consider in determining whether a rebellion existed or whether there was interference with federal government functions. And, finally, right, we have this question of what it means for the president to be unable with the regular forces to execute the laws. The administration has argued that these regular forces refer to law enforcement officers. An important amicus brief by Marty Lederman has argued that it should properly be understood to refer to the federal army. And this is all teed up for the Supreme Court's review kind of as we speak, and I expect we will get a decision in the days and weeks to come. Okay, now that's a lot of really kind of technical minutia. What I want to do is step back for a moment and underline for our purposes just how much of this confusion stems from the fact that the statute is framed incredibly broadly, with terms that are not well defined, and without the kind of substantive guardrails which later statutes have routinely deployed. So, for example, if you look at Section 12304 of Title 10, this is another statute authorizing the president or secretary of defense to federalize the National Guard. But it provides far more in the way of limitations on what that discretion looks like, right? So it authorizes the federalization of the National Guard in response to a use or threatened use of weapons of mass destruction, or in response to a terrorist attack or threatened terrorist attack that could result in significant loss of life or property. It provides a timeline for how long the National Guard can be on duty. It requires congressional notice, and it provides a ceiling for the number of National Guard which can be deployed. We see none of these attempts at cabining the president in Section 12406, for example. Okay, so that's bucket one, right? Federalizing the National Guard. Now we need some kind of legal authority to actually go forth and do a mission. And in the context of Portland, Los Angeles, and Chicago, what we have here is a theory of inherent presidential authority, as I mentioned before, called the protective power. The kind of modern articulation of this theory started in the 1970s, and it goes roughly as follows. The president, by virtue of his authority under Article 2 and the Take Care Clause particularly, has an implied authority to use the military to protect federal persons, properties, and functions. Okay, what activities has the Justice Department traditionally understood to fall within the ambit of this protective function? Historically, it's only been those actions necessary for the protection of those, persons or properties or functions, and includes things like temporary detentions or cursory searches. Okay, where do we get this power from the Take Care Clause, right? It's not obvious from the text of the Take Care Clause. A few things that I want to mention here. So I tend to think that the most important source of authority that the Justice Department is really kind of reaching into here is history. So variations on this theory have been swimming around the executive branch since Millard Fillmore used the military to recapture and detain an accused runaway enslaved person by the name of Shadrach in Boston in the 1850s. But the theory really kind of came into its own after the Civil War, and it's been articulated in various ways since then. Importantly, throughout that early history, this theory was rooted not in any text of the Constitution, but in theories of necessity and sovereignty, which we don't see in modern justifications for the protective power. Okay, this leads us to the second and the justification for the protective power, which is more squarely presented in the Justice Department's briefing that we've seen so far, most recently by the Solicitor General in the Chicago litigation. And this is to rely on cases from the 1800s, primarily in re Nagel, as standing for broad assertions of presidential power under the Take Care Clause. All right, so for folks who don't know, In re Nagel is this absolutely fascinating, amazing case where you have Justice of the Supreme Court on a train in California, and there is a jilted couple from a prior case in a divorce proceeding that he dealt with, and the husband attempts to assassinate the justice, and our U.S. Marshal Nagel steps in to subdue, kill the husband. And the question before the Supreme Court is whether this marshal had the authority to protect the Supreme Court justice. And in response, right, the Supreme Court lays out in what is pretty clearly dicta an incredibly broad understanding of the president's authority to protect the functions of the federal government. And so I want to pause on a few things here. So first, I just want to pause on whether we think this theory of the take care clause stands up to scrutiny. And I don't think it does. And I'll get into just a few reasons why in a moment. And then the second question is to ask, all right, if you think that this authority does exist, well, how does it interface with what is by far the most important statutory limit that we have regarding domestic military deployments, the Posse Comitatus Act? Okay, so let's do the first thing first. Do we think that this theory of presidential power makes any sense? I think there are a lot of reasons to be skeptical of the executive branch's interpretation of the take care clause here. If we stipulate for the moment that we think the take care clause is capable of an interpretation greater than some kind of like fiduciary duty to actually enforce the laws, that, in other words, right, to say that the take care clause actually grants some positive authority on the president, then I think we are pretty squarely in what we would now think of as Youngstown territory, right? And when we do a Youngstown analysis, right, we're asking whether the president's constitutional authorities, right, have been cabined by the legitimate exercise of Congress's own authorities. And here, I think that there is a very strong argument for saying that it has. There is a huge body of statutory law by which Congress has dedicated the protection of federal functions and federal properties and federal personnel to federal law enforcement agencies. A lot of these statutes are really specific. So, for example, there is the creation of the U.S. Marshal Service or the Secret Service. For folks in Florida, right, there's also statutes, for example, that authorize using the military to protect federal timber in Florida. And other statutes are far more broad, right? So we have the statute that creates the Federal Protective Service, for example, which literally provides to the Secretary of Homeland Security the obligation to protect federal properties and personnel, right? And we could go on. Congress has provided in great detail how the president may use the military to assist these federal law enforcement functions. There's the Florida Timber Statute that I mentioned. There are the provisions of the Insurrection Act, right, which we haven't even gotten into yet. We could go on, right? This is an area where Congress has legislated extensively. So I think it's pretty clear that statutory law has entirely occupied the field here. Okay, so if even if you're kind of skeptical of that claim, and that are inclined to defer to the executive branch's historical practice, I think importantly, there's also been a lot less continuity here than appears at first glance. So the scope of action authorized by the protective power, at least in the executive branch's recounting of it, has changed considerably over time. Initially, historically, I'm talking here about the late 1800s to mid 1900s, the protective power is understood pretty narrowly as an authority to protect federal properties primarily and the federal individuals who are on that property. The shift to understanding it as a broader mandate to protect federal functions only comes from a series of OLC opinions in the 1970s. And then second, the legal theory that underpins this whole kind of theory of constitutional interpretation has itself changed radically, as I mentioned before. Up until, again, the 60s and 70s, it really is a theory rooted in ideas of federal sovereignty and the requirements of necessity. Okay, so let's stipulate again that I'm wrong about most of what I've just said. And the president has some version of this protective power, right, to use the military. There is another limitation that is incredibly important here, and that's the limitations imposed by the Posse Comitatus Act. This is another extremely old statute. Its enactment pretty much brings to a close Reconstruction. It was originally enacted as a rider on the Army's appropriations. Again, appropriations law rearing its head. And what it does is it criminalizes, except in cases and under circumstances expressly authorized by the Constitution or Act of Congress, any willful use of any part of the Army, Navy, Space Force, Marine Corps, etc., as a posse comitatus or otherwise to execute the laws. So there's no Supreme Court case law defining what precisely this statute means, but we do have a number of circuit court opinions construing the PCA. And they have basically said that the act prohibits using the military for any activity which is regulatory or prescriptive, or put another way, any use of the military which pervades the law enforcement activity. Now, there are at least two possibilities, right, about how the protective power interfaces with this prohibition. The first might be to argue that it is an express grant of authority under the Constitution and therefore an express exception to the PCA. I think that this is a pretty clearly incorrect, even under the strongest version of an interpretation of the Take Care Clause. I think it's pretty uncontroversial to say that the text is not express in authorizing the president to use the military. Indeed, if you look at War Department and Defense Department regulations implementing the Posse Comitatus Act since its enactment, they have never listed the Take Care Clause as an express exception to the act. A second and more nuanced view, right, would be to say that the protective power, falls below the line of activities which are prohibited by the act. This could be plausible, but it runs into a number of practical issues. Because let's say, for example, you're using the military to displace the police and protect a federal building, or using the military to temporarily detain someone for an hour or more. Can we really say that these steps don't pervade the law enforcement activity? It certainly seems prescriptive, for example. How do you create standing rules for the use of force to prevent the military from stepping over whatever the line is here? I think it creates a practical conundrum that I have not seen a satisfying answer to. Okay. Again, that was a whole lot, but that is basically the body of law that we are dealing with in the current deployments out of LA, Chicago, and Portland. But once again, I want to take a step back and to situate kind of these legal debates within a broader set of kind of hard legal questions. So we've really only touched the surface of the laws concerning domestic military deployments, which presidents can avail themselves of. Many of the domestic military deployments that we're seeing at the southern border, for example, are based on statutory grants of authority to use the military in support of domestic counter-drug operations. I'm not going to get into those now, though I'd be happy to talk about them later. But these statutes, I think importantly for our purposes right now, what they've done is create a bureaucratic mechanism of military law enforcement integration that is being exploited incredibly effectively by the current administration. To put it another way, right, these long-standing statutes integrating the military into counter-drug operations, both overseas and in the United States, have created all of the bureaucratic pathways that you need to use the military on a much broader basis along the lines that we're currently seeing for activities that go far beyond the counter-drug context that was originally envisioned by Congress. There are also, for example, provisions of the Insurrection Act that are relevant here, not because they're currently being used, but because they are, at the very least, being discussed as a possible future basis for deploying the military. Now, the provisions of the Insurrection Act are actually kind of a body of a few different statutes enacted across the 18th and 19th centuries. Much like the other statutes we've been talking about today, they use incredibly broad language to authorize the president to use the military in the United States. So just a couple of examples. Section 252 of Title 10 provides that whenever the president considers that unlawful obstructions, combinations, or assemblages, or a rebellion against the authority of the United States make it impracticable to enforce the laws of the United States by the ordinary course of judicial proceedings, he may call into federal service the militia or the armed forces to enforce those laws or to suppress the rebellion. Now, there is a lot of case law, importantly, Martin versus Mott again here, suggesting that the president has a lot of discretion in determining whether those factual circumstances in Section 252 are met in any given context. But that's not to say that there's no standards here, right? The Office of Legal Counsel in the Department of Justice has asserted in a number of memoranda that they understand these authorities to be available only after local and state law enforcement capacities have been exhausted. There's only so much we can do with these opinions, right? And this has motivated individuals from really across the political spectrum to advocate for modernization of the Insurrection Act. But unfortunately, at least during the 4 years of the Biden administration, those attempts at reform didn't go anywhere. So again, all this is to say, even once we get to the end of the current litigation regarding Section 12406 and the protective power, we're not at the end of the road. There is a broader body of law, and I'm thinking now particularly about the Insurrection Act, which I entirely expect will become the basis for future military deployments. Okay. So what I'm going to do now is pivot to thinking about the future and what we might expect to occur next. What I want to be talking about here for the next few minutes is a possibility which I think has gotten a bit more airtime recently, but I expect will dominate our conversations more explicitly in the years to come, which is uses of the military in and around election sites or otherwise to influence elections. There are two criminal statutes that are at issue here. Like the Posse Comitatus Act, they're both born of the Civil War. In this case, they're actually enacted in the midst of the Civil War in response to the Lincoln administration using the military to block voters from coming to the polls and to block candidates from standing for election in a few different border states. So the first criminal statute here is Section 592 of Title 18, and it prohibits, quote, ordering, bringing, keeping, or having under their authority or control, end quote, troops at a place where an election is being held unless that deployment is necessary to repel, quote, the armed enemies of the United States. The second statute that we have here, Section 593, and it again prohibits an itemized list of activities which would infringe on an individual's ability to exercise the right to vote. Now, there are, a laundry list of issues with both of these statutes, again, largely stemming from the fact that they are incredibly old and ambiguously framed. For example, who can the president deem is an armed enemy of the United States? There's no definition in the statute, though I think the best read would be to require something akin to an invading armed force along the lines of the Confederate forces, which were clearly in the minds of legislators when they were framing this statute. But it's not helpful, at the very least, right, that we don't have these guardrails specifically articulated anywhere in the text of the statute. More problematic is the fact that Section 593 only applies to federal military personnel. And this is a problem primarily because of a mobilization authority that we haven't talked about yet, but which I expect will be used with increasing frequency going forward. And that's Section 502 of Title 32. All right. Now, the National Guard, as I said before, right, on any given Monday, these are civilians. You have to mobilize them into a duty status. Usually and historically, it was clean. You mobilize them into state status, and they were under the command and control of their governor, or you mobilize them into federal status, and they were under the command and control of the president. What Section 502 of Title 32 does is mix these two possibilities. So what it does is it authorizes the president or secretary of defense to request that a governor make available his or her National Guard to conduct a federal mission while in their state status, right? This has any number of implications. For example, it means that the Posse Comitatus Act does not apply to these National Guard personnel when they are conducting that federal mission. And as I said just a moment ago, it also means that the prohibitions of Section 593 don't apply to these National Guard personnel when they're mobilized into this hybrid duty status. Now, there is a lot of debate now about the kind of scope and limitations on Section 502 duty status. So, for example, it is uncontroversial that you need the consent of the governor that's providing the National Guard forces before you can deploy them. What is much less clear is whether you need the consent of the governor of the state where those troops are being deployed to also consent to the deployment. The statute is silent on that question. Folks have argued that, due to co-equal state sovereignty, we would think that one state should be able to object to a deployment of the state militia into their state. On the other hand, there have now been at least a few decades of practice where National Guard personnel in this hybrid status have been deployed across state lines, at least without the explicit consent of the territorial governor. So these are hard questions. They will eventually be litigated once they are used in these more controversial contexts, and we'll have to see how much work kind of 10th Amendment concerns and things of that nature are really going to play in that litigation. Okay, so that's just a flavor, I think, of some of the issues which I expect will come up over, again, the months and the years to come. There's more to say, and I'm looking forward to the question and answer session afterwards. But I think to step again back and a bit of closing, this area of law is one that has primarily relied on norms to cabin the use of the military in the United States. And what we're currently seeing is an environment where those norms are being attacked and where they are falling away, which exposes us really just to the legal architecture, the pretty bare legal architecture that exists underneath those norms. And so there are going to be lots of hard questions that courts are going to be addressing. And I'm looking forward to folks' questions afterwards. Thank you.
Well, thank you. That's a great deal to take in, but it's absolutely terrific. And I'm very grateful to you for doing this. We'll take our usual short break and then reconvene.